These are the wrap-up slides for Class 5 on entity attributes and director obligations. So we started the class by talking about limited liability, which is one of the attributes we often associate with the artificial entities we create. Obviously, not all entities have limited liability. Partnerships don't. But corporations do, LLCs do, and there are a variety of limited liability features in the proliferation of new entities that we've seen, like LLPs, LPs, and the like. And so understanding limited liability is important conceptually. I tried to start talking about the ways in which you could create something like limited liability through contract. And the point of that discussion is to try to highlight who in some sense bears the costs associated with limited liability. Consensual creditors, people who are voluntary creditors in a situation, are effectively able to negotiate either into a kind of limited liability arrangement or around actual limited liability arrangements. So I spent some time talking about non-recourse debt, which would be a contractual tool that in a world without separate entities, an individual could create vis-a-vis creditors limits on the assets that those creditors could look to. And that's effectively what we do when we build these limited liability entities. We're limiting assets that creditors can look to, separating those assets from the personal assets of an individual. And a non-recourse obligation does that without the extra layer of this separate artificial entity. That's true for consensual creditors. Non-consensual creditors, tort victims, environmental victims, the government, those are not situations where you can necessarily use this tool of non-recourse debt to limit liability. You need something else to do that. In similar fashion, to flip it around, in situations where you've got a limited liability entity, a corporation, and think of this as sort of a closely held corporation, if that corporation goes to borrow money from a bank and the bank isn't happy with limiting its claims to those of this entity, it'll ask for a personal guarantee from the owner. And that guarantee is effectively a waiver of limited liability as to that particular creditor. So consensual creditors can do that both ways. They can, as it were, opt into limited liability type arrangements without the creation of a separate entity, and that's what you do through non-recourse debt. But they can also, in even situations where we have actual limited liability entities, negotiate around that for effectively a waiver of limited liability through things like personal guarantees. What that all means ultimately is that if you ask in some sense who bears the burden or the risks associated with limited liability entities, the answer is non-consensual creditors. That's the group that can't negotiate around limited liability, and the group that an entrepreneur operating as a sole proprietor couldn't get to agree in advance to non-recourse obligations. Talked a little bit about the benefits of limited liability. Part of what obviously characterizes the modern large enterprise is the separation of ownership and control. And in a situation where you as a shareholder are turning over control over the assets of the firm to someone else, if through that control that person could put your personal assets at risk, that would really change the risk profile of being a shareholder in a particular firm. You might be more reluctant to separate ownership and control. And so if we think there are benefits of specialization, some people are good operators, some people are appropriate owners, then we may think that limited liability helps to facilitate that separation. As that discussion also suggests, that's going to have consequences for potential diversification. If I make an investment in a firm and I'm putting all of my assets at risk by doing that, I'm naturally going to want to limit the number of firms I invest in. And we know that there are benefits to diversification for investors. And finally, it goes to the kinds of pooling that occurs when we have shareholders who in some sense are organized together. In a world in which we don't have limited liability, then I care about the wealth of my fellow shareholders because the liability of the firm may be borne by us. And if it turns out that you don't have any assets, you are judgment proof, then I may get stuck with a disproportionate share of that liability. Again, limited liability solves all of those problems. We then talked a little bit about taxation at a pretty high level. And so the critical point there is this idea that when we have corporations, we have what's the classic double taxation problem, that we will have taxation that takes place at the corporate level, and then taxation that will take place at the individual level. And if we run I'll say at least in theory, right? Obviously the tax system is complicated, and the extent to which a particular corporation pays taxes is not necessarily indicated by the general rules. But that means that in those circumstances, at least in concept, you should be nervous about that we will be discouraging people from using corporations. And if limited liability entities have all the benefits we've described, we are literally taxing them, and we have this double incidence. So what you might like to have are entities where you get the benefits of liability and treatment as partnerships from a tax standpoint. And that's really the emergence of a new class of entities where that's possible, LLCs often, which has been sort of the reason we've seen the formation of these new entity types in the last 10 to 20 years. Also talked a little about this idea about the distinction between mandatory terms in entity creation and default terms. Mandatory terms are those which you cannot control when you set up the entity, that the state simply assigns to you. Default terms are those which the state will say, here are the off-the-rack terms that apply if you don't say anything, but you have full control to change these terms. Those are very different. We spent a little bit of time talking about the circumstances under which you might want to do that. I'm not sure we have a good understanding of that. The circumstances, we look at one particular one, but the circumstances under which you see these mandatory terms are often things like non-waivers of fiduciary obligations. We talked through the way in which we would think that those would be the terms that people would actually be pretty focused on when they were organizing a partnership or a limited partnership. So there's a way in which it's sort of odd to make mandatory the thing which you might think people would most naturally pay attention to. And I hope the discussion in class made clear the downside of those mandatory terms, that there are all sorts of refined judgments that you need to make about the duty of loyalty and the duty of care in particular situations, and that one could imagine sophisticated parties wanting some flexibility on that in a way that the mandatory terms may not be consistent with. From there we went to the Van Gorkum case. And the Van Gorkum case is obviously an exercise in looking at these fiduciary duties at work. Van Gorkum is a duty of care case, not a duty of loyalty case, so we kicked around some loyalty issues in the context of talking about it. Van Gorkum is as it were famous or infamous, in part because it's relatively rare to find corporate law cases in which directors are held liable. We talked through the facts, and I did my job of trying to play devil's advocate and sustain whatever the other side is that needs sustaining. But it's hard to do that in that case. There were any number of natural steps that the directors could have taken, and had they taken maybe any of them, they would have, I think, limited their exposure in that situation. We've talked a little bit about the role of state law versus federal law, and this question of uniformity versus non-uniformity. Obviously, state law, corporate law in the United States is done at the state law level, and Delaware has been an aggressive competitor in that domain, and competed once again after Van Gorkum came out, where they immediately made a change to the statute to give corporations the option to effectively limit the extent to which directors could be held liable for the violating the duty of care in these circumstances. So Delaware was quite responsive to Van Gorkum, as my understanding were the corporations incorporated in Delaware, and many of whom adopted the provisions that the amendment made possible. From there, we went to a discussion of securities law, and one of I think the key distinctions there is this distinction between insiders and outsiders. So, and that's a question of the symmetry of the information, that outsiders are in some sense symmetrically situated. They have access to the same public information, while insiders, by definition, have access to non-public information. And our insider trading regime is all about controlling the ability of insiders to exploit that information as against outsiders. We don't have those same concerns in outsider situations, and BASIC is effectively an outsider situation. I don't think the court focuses on that, and I think the consequence of that is that rather than focusing on sort of, well, how would the shareholders as a group think about the question of when should there be disclosure of merger discussions, where it's not obvious to me that for the shareholders as a group that there's any need to disclose that, and at any point prior to the point at which the merger is basically done. How is it benefiting the firm, which the shareholders as a whole, that's what they care about? How is it benefiting the firm to disclose that information? That seems to be the question, and that's not what the analysis is in BASIC versus Levinson. BASIC instead focuses on this question of sort of, well, what would a reasonable shareholder want to know, as opposed to what's in the best interest of the firm as a whole, which is what the shareholders as a group should be focusing on. We also talked about the mechanics of class actions and the role that the fraud on the market theory plays there. The nature of a class action is that you need to have sufficient commonality among the members of the class to maintain the class action. It's just one of the rules of Rule 23 of the Federal Rules of Civil Procedure, which is where the class action idea is situated. And in a situation where you've got firms making statements, and in BASIC versus Levinson, multiple statements, how do you go about showing practically who heard what and how they relied on it? What's the causal connection between the statement and your decision to sell or not sell the security in question? If you actually had to establish that individually, you'd either have lots of class actions, different class actions for groups that are differently situated on those facts, or you wouldn't be able to do class actions. Class actions obviously are a tool designed to make it possible to aggregate what might be a series of small claims into a single larger claim to provide the appropriate incentive to bring the to chase the alleged violation in the first place. So if you have this individualized reliance inquiry, it can be difficult to do the class action. Fraud on the market theory solves that problem in saying that what we're going to focus on is this idea that the information was public, that therefore that information will be reflected in the market price that you traded at, and that's true whether you heard or didn't hear the information. So the fraud on the market theory emerges as a tool to solve the reliance problem that the class action might otherwise face in these circumstances. Okay, that's what we talked about in Class 5.